Today's topic is not strictly a family law one, but every once in a while I deviate into something that I think affects family law attorneys along with all other attorneys. And I'm going to talk about a topic in which I have some professional experience, and that what's happening in this area bothers me a bit. And it's the area of lawyer regulation. First of all, in terms of my experience for 30 years now about. I've been serving as retained counsel for first BAPR and now OLR. And just so it's clear what that means, I'm hired by OLR in an individual case to serve as their counsel, sort of like a prosecutor, except of course it's civil, in prosecuting lawyers in individual cases for ethical violations. I'm not an employee of OLR, and therefore the opinions stated herein are not necessarily the opinions of OLR, they're just my personal opinions. And it relates to a study commission that's been going on and that entered its interim report, or made its interim report and signed it recently. I think October of 2018 was a formal name. Judge Potasic, I think I'm pronouncing that correctly, was the chair of the committee. It was a great committee, I assume appointed by the Supreme Court, to study the disciplinary system and make recommendations for change. And I've read the report. It's quite lengthy. It's, if it's not now, it'll shortly be available on WizBar for anybody who would like to read it. And I don't criticize the people who did the report, did the work. It's a lot of hard work and a lot of effort that went into it. But as someone who's been involved for 30 years now in the disciplinary system, I feel my comments fall somewhat in the neighborhood of the emperor has no clothes, in this case, the emperor being the Supreme Court. I understand that this commission, I assume, was appointed by the Supreme Court and working at their direction, and yet among the recommendations that this commission sees, it totally ignores. It's not even a swing and miss. A swing and miss requires that a ball be thrown and you make an effort at hitting it. There's no ball being thrown. They totally ignore what I see as the two biggest issues and problems in the disciplinary system. And the reason I think it falls within the context of the emperor has no clothes is both of them fall at the feet of the Wisconsin Supreme Court. And maybe it's because I got a lot of gray hair these days, and I'm not afraid of saying, hey, look at the emperor has no clothes. But I think somebody ought to say it, and somebody ought to point out what these problems are, because otherwise, to the extent the disciplinary system has problems, and it does, a report which ignores them because they lay at the feet of the Supreme Court really isn't doing, I think, a lot of services to the state bar and to the public, which are, who are served by these attorneys. The first problem, and to my mind, the biggest problem in our disciplinary system, and it's probably different than a lot of lawyers think. A lot of lawyers probably think that the system's too hard on lawyers, and a lot of citizens probably think it's not hard enough on lawyers. And you could look at individual cases and argue one way or the other, but they tend to be anecdotal. I don't think either one points out what the largest problem is. And to me, the largest problem is the amount of time it takes from grievance to final resolution. That is a multi-step process. It starts with the filing of a grievance, of an investigation. If the preliminary review committee recommends charges, then there is a prosecutorial phase, unless the lawyer stipulates to the discipline. And the prosecutorial phase includes potential litigation, and then after the litigation, it goes to the Supreme Court and makes a decision. That process can take an unbelievable amount of time. And please understand, when I'm representing OLR, most of the cases I have victims who were misserved by the lawyers, sometimes defrauded, sometimes had money stolen by the lawyer. And it is these victims that I'm most concerned with, because they're waiting years, not months, but years for final resolution. The largest delay is not the investigatory phase. I wish that could be faster, but that's a resource thing. That's giving OLR sufficient investigators to do their work. The ones they have the work I've seen from them is outstanding, and they've done it diligently, and they work hard. It's not the PRC. They meet, get their work done. It's not the prosecutorial stage. I've had some referees that I think are a little bit slow in getting things done, sometimes not timely with their reports, but that's anecdotal. For the most parts, most referees have been involved in schedule discovery deadlines, trial dates, and get their reports and recommendations in promptly. The problem that I see is at the Supreme Court level, and this recommendation by Judge Patak's committee doesn't even discuss it, doesn't even look at it. And let me just give you a couple of examples. I had a case where we needed a new referee appointed. There was a conflict, and Supreme Court said, we'll appoint a new referee, and waited 2.5 months. I mean, you have a list of referees, appoint the next one on the list. Should take 10 seconds. I had a case where there was a motion filed during the case, and it wasn't complicated. It's nothing difficult. It's not evidentiary. Both sides submitted briefs, and a year and a half later, the Supreme Court decided the motion. In the meantime, the case just sits there. And I'm having witnesses call me, and I say, there's nothing I can do. I submitted the case. I had a case once involving a lawyer charged with lack of diligence. And we try the case, the referee makes a recommendation, and the case from there goes to the Supreme Court, and it took them over a year to decide. Now, understand the Supreme Court doesn't work during the summer. You can comment on that. Make up your own comment on that, okay? So there's 3 months right there where nothing happens. But it just sits there. And it got to the point where I called OLR, my client in the case, and I said, the lack of diligence by the Supreme Court exceeds the lack of diligence by the attorney in this case, because the case is just sitting there. Nothing was happening, and they just didn't make a decision. And there's nothing you can do about it. You just sit and wait and hope that they didn't lose it. And let me point out the most egregious example. There's a case called involving an attorney named John Kenyatta Riley. And if you want to look it up, it's 2010 AP 2942. There was a disciplinary procedure. Referee made a recommendation. There was an appeal. As sometimes happens, there were oral arguments on the appeal. The oral arguments obviously end the evidentiary stage, or at least litigation stage of the case, so there's nothing to do except to wait for the Supreme Court. It was not an overly complicated case. It wasn't an overly difficult one. The oral arguments in the case occurred on October 23rd, 2012. The Supreme Court decision was July 15, 2016. As you may know, when they take the summer off, they issue a whole bunch of opinions the end of June, early July, everything left over. Well, if this had been July 2013, 7, 8 months or whatever after the oral arguments, you'd say, oh, it's a long time to wait, but whatever. But this is 3.5 years after the oral arguments, before the Supreme Court reached a decision. And it's just absurd. And to me, that's the biggest problem I see in the disciplinary system, is the amount of time it takes at the Supreme Court level for them to make decisions in cases. Sometimes it's appointing a referee. I've had it wait, as I said, in the one case, 2.5 months. So it just sits there, and you wait for them. And after they get a decision, if it comes in after June 15th or June 30th, whenever their cutoff is, you have to wait till October. And oftentimes it's way, way beyond there. You wait months and months for a decision. The second problem I see with the disciplinary system is the lack of consistency regarding discipline for lawyers. So you have a lawyer who's done something wrong. They have been found guilty, essentially, of violating the ethical rule, and then there's a sanctions phase. And assuming there's an agreement, which happens sometimes, or a trial, and the referee decides, and the Supreme Court decides on the violation, the question is what sanctions should be imposed. And there's no rhyme or rule for it. There are cases that come down where I've seen lawyers do things that I think are horribly egregious. For example, lying to a court. And they get a hand slap, and others where I think the violations, to my mind, are less severe, and the Supreme Court gives a more severe sanction, and there's no reason given. Supreme Court sometimes will cite a case, a couple cases, but oftentimes they say, well, based upon the files and records of this case and what we see here, we think the following is the correct sanctions, with very little reason. And there are no guidelines, there are no rules. And the thing that bothers me the most in their inconsistency, and I think the most difficult thing for lawyers like me and those of you listening, watching this, who are practicing, is in the reputation of the legal community are the multiple offenders. Lawyers can make a mistake. I don't have any problem with that. I've been involved in several reinstatement proceedings where lawyers have done things wrong and have been suspended and then applied for reinstatement and have spent their time going into sometimes mental health treatment, sometimes drug and alcohol treatment, getting into counseling, have really cleaned up their act and deserve to get their licenses back, and have been involved in several of those cases. It's not the one time and out. It's not what I'm saying. It's the ones who've been involved in 2, 3, 4, 5 violations. And the Supreme Court has an unwritten, informal rule that you see in some of their opinions that's called progressive discipline. And progressive discipline is supposed to go like this. A lawyer, first violation, assuming it's not stealing money, it's something more minor, may get a private reprimand. The second time, a public reprimand. The third time, a short suspension. Fourth time, if there is one, a longer suspension. And point being, like in a criminal court, if you have a prior record, you get a longer sentence. That rule, which is cited in any number of Supreme Court cases they talk about, is an informal, unwritten rule that each case should have stronger discipline than a previous one because the lawyer has shown that he or she cannot abide by the terms of the Supreme Court ethical rules, is not followed by the Supreme Court except in theory. And there are any number of cases where they have had lawyers who've had 2, 3, 4 violations, and the next case they give a lesser sanction. Well, how in the world can any lawyer figure out what system we have, what type of sense, what type of logic, or more than that, clients and the public out there have any faith in our legal system when the Supreme Court says we have a system of progressive discipline and doesn't follow it, and moreover, when we have lawyers who commit multiple offenses and these sanctions get less. Once again, no place in this report, unless I missed it, in which case please let me know, but do I see anything regarding the problem with a lack of consistency with Supreme Court sanctions. Maybe I missed it. I don't even see it mentioned in this report. So the report goes through a lot of things. It makes a lot of recommendations. Most of them are perfectly fine. None of them address the 2 major problems. And I'm not trying to offend anyone here on the committee. I'm sure, commission or committee, I'm sure they worked very, very hard on this. But I'm guessing when you're appointed by the Supreme Court, you don't want to bite the hand that appointed you. And none of the recommendations, none of the studies, none of the appendixes, nothing that went into the report addresses the problem at the Supreme Court level, which I think is the most important and strongest area that needs to be improved in our disciplinary system. For more on this, if you're interested, I'm going to be writing a column on this for the Wisconsin Law Journal next month, and invite you to listen to that. And if you enjoy these podcasts, I would suggest you click on the like and subscribe button below. And if you have ideas for future podcasts or articles for my Wisconsin Law Journal, please let me know.